Welcome to a Beresfrod Booth webinar series. My name is Linda Nash. I'm here with my colleague, Makenna Hoffard. We are state planning attorneys here at Beresfrod Booth. And today we're into our third part of our four-part series, Understanding Trust 101. Before we get into part 3 of our series, How Do Trusts Work, I thought we'd do a quick recap of what we covered in the first 2 parts of our series.
Yeah. So our first one is, of course, what is a trust? The definition we created by melding a bunch of different definitions is that a trust is a legal agreement whereby the owner of property gives the property to a trusted individual for a specific purpose to benefit a person, organization, entity, or animal. A trust is some form of contract where that person is holding something for someone else. We also define the different terminology, so that's important to know for today. The trustee is the person holding title to whatever property is in the trust. The trustor, when we say that, that's the person who created the trust and essentially handed that property to the trustee for the trustee to hold for the other party, the third party. The third party in that instance is the beneficiary. That's the person who is going to benefit from that property either while it's in trust or after it's released from the trust. And then the principal is our name for the property that's being held in the trust. It can be, like we said here, real property, cash, investments, cars, just about anything. There are some restrictions, but almost anything can be held in trust. And then every trust that we do has that trust agreement. That's the document that outlines what's being held, who's holding it, who gave it to them, who it's going to, all of those details. And the goal of today is going over kind of the questions for actually setting up that trust. When a client comes in and a trust is a good fit for them, what we're going to go over is what do you need and why, where we answer those questions. So, Lynn, do you want to do an overview?
Yeah, like Makenna said, basically we're going to kind of follow the format here of we have clients come in and we meet with them and we talk about their assets and situations and we decide a trust of some kind or another is going to work and be benefit the clients and it's right for them. This is sort of the framework that we go through. The first thing we do obviously is what type of trust do you need? If we've discussed nothing else in this seminar, it's that there are so many different kinds of trusts. And so we talk about revocable, irrevocable, created during your life or not, and we're going to get into more detail in that. And then the second part, which is really, I think, the bulk of what we talk to our clients about really is the terms of your trust is you get to create the rule book, which is basically what your trustee, what rules are they going to follow with respect to how to manage the assets and benefit the beneficiaries.
Mm-hmm. And then the last part.
Oh, go ahead.
Oh, yeah, just the last part is when the trust terminates. So trust cannot continue forever. There's a rule strictly against that. The public policy is just we don't want someone controlling assets after their death for a long time, but you're allowed to for some set number of years, but there does need to be a time when the trust ends. And there's a lot of different ways that it can terminate. So we'll discuss that too. Yeah. Okay. So types of trust.
Yeah, so we already covered, I think, a little bit of this before. There's basically two types of trust, revocable or irrevocable. A revocable trust, which is the majority of the trusts that we work with our clients is that the trustor or the trustors, if there's more than one, they can create the trust, they can fund the trust, but at any time while they're alive, they can undo the trust. Basically, they could change their mind and say, you know what, I decided I didn't really like this trust, or I like it, but I'm going to go in and change some of the terms. So that's what we mean when you hear revocable trust. I think for most people working on estate planning, they hear the term revocable living trust. That's basically a trust that you set up during your lifetime, individually or as a husband and wife, and you transfer your assets into that trust because having your assets in a revocable trust works best for you. I think we talked about that in our earlier series about why you might need a trust. But until a person, until the trustor dies, a revocable trust can always be undone. And then the second type is an irrevocable trust. That is where the trustor intentionally is creating a trust that once he signs it, he or she signs it, the terms of that trust cannot be changed or undone. Of course, there's an exception to some rules, but for the most part, the most important terms of an irrevocable trust cannot be changed. The trustor, once they give those assets to that trust, cannot be taken back, and the terms can't be changed. And there's a lot of different types of irrevocable trusts. Makenna's going to talk about trusts that are created while you're alive, and when you pass away, you can create an irrevocable trust while you are living. But an irrevocable trust can also come into being after you pass away.
Yeah. Yep. So the bottom two terms here, we talked about this in prior webinars, but there's testamentary trust and inter vivos trust, which Linda talked about. Testamentary just means it's part of your will. It only comes into existence if certain things happen after your death or at the time of your death. So this trust will spring forth from your will. The terms are all set. The rule book is all contained in your will itself. Inter vivos trusts just mean while you're alive. Usually the most common one we work with is the revocable living trust. So revocable inter vivos trust, where you put the money in and you can take the money out. And one of the things that can often be a bit confusing is that the trust is revocable while both trustors are alive, right? If it's a husband, wife putting money in, that trust can be revoked. They can both sign a paper saying they're revoking it, it's done. Or just one of them could revoke as to their share of the trust. And then at the first spouse's death, so say everything goes into the trust, they live for another 60 years happily, husband dies, his half gets locked in, and we'll talk about that later too, but it becomes irrevocable while wife retains her power and authority to revoke as to her half. She can change her distribution pattern. Husband's is locked in though, and she doesn't have authority to change his. That's a really common way where something will move from revocable to irrevocable, even though it's like a living trust and all of that, it will swap over.
And also something to keep in mind about testamentary trust when you use that term. That's also applicable to trust created within another trust. Testamentary means that it arises only upon somebody's death. So if you're keeping track, your revocable trust can create a testamentory trust.
It's not confusing at all.
No. So when you're talking about what type of trust you need, basically you want to look at, what are the goals of the clients? Why are you creating this trust? With a revocable trust, perhaps a couple is creating the trust and they're going to put all their assets into that trust for ease of management, so that if they get sick or become incapacitated or one spouse passes away, that another person, another trustee can step in and seamlessly take over managing the trust assets instead of having only assets, spread out in the couple's names, for example. Maybe it's an educational trust. Maybe you have grandchildren and your goal is to set aside money to benefit your grandchildren so they can go to college. There's lots of reasons to create a trust, but what is the end goal? Do I want to take care of specific people? Do I want to provide these benefits or take care of, charities or pets, as we're going to talk a little about here in a bit.
Yeah, that's for sure. Okay. That takes us to the fun part where we really dig into the details, where we create that rule book. The big thing is like, well, who gets to set the terms? What has to be in it? You do. Whoever is creating the trust gets to decide what it says, what's in it. We both have had experience with really unique trust terms being
Yes.
added in, things we never would have thought of, things that just they don't teach you in law school. But when, a client asks, so can I add this in? Can I make this a requirement? Can I make this a restriction? Almost always the answer is yes. We'll get into limitations, but yeah, the main things to keep in mind, and we're going to just harp on this whole webinar, is thinking about the purpose of your trust, and if there's a specific end goal, that will inform if there's any restrictions that have to be in place in order to obtain that goal. If you're doing it for tax planning, you're going to need to include certain tax provisions.
Right.
If you're doing it for a child's welfare, you're going to need provisions that allow for distribution for their welfare. So there are certain things you kind of really have to include, like you have to name a beneficiary, you have to name a trustee. But there's, a lot of room for flexibility, being creative. We've seen any number of beneficiaries named, organizations, animals named.
Different iterations of trust terms. I think another thing that we hear a lot from clients, McKenna, when we talk about whether we're setting up a revocable living trust or the inter vivos trust, or we're doing wills for couples and we're setting up a trust for their children, is that they're like, well, what are we supposed to put in there? Like, what do we have to put in there? And that's a common misconception that we try to talk to our clients about. And we'll give you framework guidelines to start with. We're going to talk about, like, for example, the term of a trust for your children under your will here in a little bit. And we could give you, and based on our experience, where we like to start out with, for a trust for your children, what ages they can receive funds, etc. But those really are, that's just a starting point. This is all based, again, on what you want. And we will tell you if what you need to do to accomplish that goal, and if your trust can accomplish that goal. Which brings us to the next topic, is that there are limits to what you can put into a trust.
Yep. So you can't do anything illegal, and you can't do anything against public policy, which is a much squishier term. So the fun examples we came up with is you can't demand that the trustee commit fraud, or theft or something like that. And you can't demand the money be used for something illegal, like purchasing illegal drugs. And then, do you want to talk about public policy, Linda?
Yeah, public policy is it's like McKenna said, it's a squishy term, but basically the courts and case law have come to hold that the trusts or contracts that have terms that are against public policy are going to be held invalid. For example, if you had a trust that said, my son can have all my money if he never gets married. Well, there is a sort of generalized public policy for marriage and for children. And so to restrict funds because you are keeping somebody from exercising a right that the courts and society in general has said, well, that's against public policy, that's going to be stricken out from your trust. Interestingly, the flip side, I think, is okay to say, to encourage marriage. You can leave assets and say, I will, if you get married, I'm going to give you, more assets. McKenna, you were telling me about the trust for pets that can't be unlimited.
Yes, there's a fun case where I forget the celebrity, but some celebrity tried to leave over $2 million to her pet dog. And her one child petitioned the court. There was a whole battle over it. And what ended up happening is the court held that that was an unreasonable amount to leave for the care of that dog. They had no reason. They needed all that money set aside for them. And so they really restricted the amount left. I think it was 200,000 at that point, which is still a lot for a dog. So they really restricted, like, the dog can live in the home, the dog can have this much money set aside for care, they should continue with reasonable care, but this money doesn't need to be held for this animal's benefit. It needs to move on to the next party named in the will. And so that you can't lock money up. That's against public policy. So yeah, public policy, just kind of anything that society deems as good for all of us.
Yeah.
Which you may agree or disagree with. But that's kind of the idea. And so that's something we always keep an eye out in drafting, to just go, is this going to get you dinged? Is this something that an outsider would view as reasonable or unreasonable, and doesn't restrict anybody else's constitutional rights?
Right.
So those are general across the board, whatever trust we do, we always watch for those.
Right.
And then there are the specific ones that just show up depending on your goal. So,
for example, and certain types of trusts are going to limit how distributions can be made, or require that certain terms be included. And a good example of this is what's called a special needs trust, or nowadays they're calling it a supplemental needs trust. This is a specific type of trust that it's typically created when you have somebody who's receiving income-based benefits like Medicaid or SSI, where if the individual was to receive too much income or too many assets, that they may become ineligible for those benefits for a period. And for some people receiving these benefits, that could be a big hit financially. And so the courts have allowed, and by statute, you're allowed to create this special needs trust. Sometimes you'll hear it called a SNT, or if we're dropping to using initials for things, you might hear us say that. Basically, the person contributes funds to the trust, they name a trustee, the beneficiary is that person, and there's guidelines as to how those distributions can be made so as not to accidentally create a period of ineligibility for the beneficiary. So it's supplemental in the sense of they're having their medical care, maybe their rent paid, maybe room and board is being paid by some sort of government or public entity. So the trust can come in and supplement those needs. They can provide additional care that's maybe not provided by under Medicaid, or those types of things. But the limitation is that trust cannot give any of those assets outright to the beneficiary. They need to make those expenditures on behalf of the beneficiary. So that's a limitation. That's a good example of a limitation of, if you want to create this trust because you have a child who is receiving benefits and you want to make sure they're cared for going forward, and that their care and their support can be supplemented. This is the type of trust you would create, but there would be limitations on how the assets could be used.
Yeah, because typically most trusts give the trustee really broad power for what it can be used for. There's some, I guess the other example that comes to mind is like the education trust, where you're really saying these funds get used to pay for tuition, books, maybe room and board while they're at school, things like that. And it's really whatever the trustor decides they want to qualify as a education expense, and it has to fall within the statutes as well. And so the special needs trust is kind of the same way, where you're really restricting what the trustee is allowed to spend money on, so that the state can't look at it and go, well, that fund, like those funds have to be used to pay for XYZ thing first, because the trust itself says you can only pay for things that the state otherwise would not pay for. And so if the state doesn't pay, those are not getting paid from the trust, which then allows for the benefits to continue.
Right.
So kind of a funny workaround that works.
And another consideration that we come across a lot when we're doing planning for couples is estate tax planning and creating a special type of trust that keeps one spouse's assets out of both spouses' estates. But those are typically called a Q-tip trust. I think we may have talked about those in our prior ones, but that's another good example of, in order to qualify for that, in order to receive the tax, the estate tax benefits, you have to have very specific terms to that trust. For example, on a Q-tip trust, the spouse can be the only beneficiary. He or she must receive all income. They can have no control over where the trust goes at the end of the day. So this is just another part where we talk about what you want to do. That example, well, I want to provide for my spouse, but when she passes away, I don't want this to be included in my estate or her estate. Then we would suggest, okay, here's what you can do, but here's the requirements that you have to have in your will or your trust for that. So, and then we are going to, one of the other questions we want to talk about is who benefits from the trust. With a revocable living trust, like we talked about, usually the beneficiaries are the trustors themselves. And this is kind of an interesting thing to talk about, McKenna, when we went back and said about the terms trustee, trustor, and beneficiary. That's what's really interesting about a revocable living trust, right? Is that they're all the same person.
You are they're all husband and wife for all three at the beginning, and then the beneficiary changes throughout the life of the trust as people pass away.
Right. Yeah.
Yeah.
So that's a good example of, and the majority of our trusts that we work with clients on are this revocable living trust. It's usually with married people, but also with single people, where you're the creator, you're the beneficiaries. And so basically, like in this scenario, the spouses benefit during their lives. And then when the first spouse passes away, the beneficiary changes to just the surviving spouse. And then when the surviving spouse passes away, then the beneficiaries change to their children or grandchildren, or perhaps charities, or some combination of both, or all three.
Yeah, and I think I mentioned this earlier, but that's just one of those, someone has to benefit from the trust. You can't just lock the money away and say it's going to be held. You get to decide who benefits, but you have to have someone benefit from it, some organization,
Right,
animal, whatever. You have to have a through line. And so whoever you go to for estate planning is going to wonder about that. We will ask you about it. You have to decide on that. So that's just one of those fixed terms for any trust across the board. You have to have a plan for beneficiaries, and we're going to ask about contingent beneficiaries. Anyone drafting a trust should ask about this, because the trust will hold it for someone, but then there should be a backup for if that organization doesn't exist at the time of your death, if that person has predeceased you, etc.
Right.
So the trust still has a clear direction for who it goes to in the event that the person you originally had in mind is not able to take it, or organization.
And I think that's a good just estate planning tip, that when we work with people and we're going through their estate plan, and we really do go down the line. Okay, first I want my spouse, then my children, well, then maybe my grandchildren, and we kind of keep going down the line. And folks often wonder, when we say, if nobody's left, who do you want it to go to? And that's such an unlikely scenario. Well, yes, that's correct, but you still want to protect where your assets could go in that unlikely event. Just because we have seen it before where somehow it ends up with there's no beneficiaries named, and now what do we do? So that's the reason your estate planning attorneys ask you that annoying question about, but what if they die? But what if they die? But what if they're not around? So
Doomsday planning. Like, okay, we're just gonna ask the crazy thing, and we're really gonna come up with, if everybody dies all at once,
right.
what's your doomsday plan?
Yes.
Okay. Anything else for this slide? Are we ready to move on?
Yeah.
Okay. Perfect. So the next question is when? We know who benefits. You've decided that. Now we're going to talk about when does everyone benefit. So sticking with the revocable living trust that we just talked about, Linda kind of covered the who changes throughout. The when also can change. It can be specified, but there's going to be a different timeline attached to each who, where at first it's the both spouses, say husband and wife put money in together, they both get to use it together. And then husband dies in our example, and wife is the sole beneficiary. But that trust should still contain provisions for when she has access to husband's money that he locked away, right? A lot of the time couples will choose to allow the spouse to use it right away. They can just use the money. They don't have to worry about it. It's in the trust, but they have freedom and access. A lot of the time, the other thing we see is you can only use it when all your money is gone, right? I really want to preserve that money goes to the kids in this way, right? So if second spouse remarries, I don't want her new husband to be taking a share of it or whatever, right? I don't want you to have free access. I want that money set aside, locked away, but you can use it if you run out of your own money. So those are kind of the two main ones we see. There is nothing stopping you, other than if you wanted to be Q-tip compliant, from making different timing there for, oh, well, you can do XYZ thing here, but if this happens, right? Or I guess the other thing we actually genuinely do a lot is at your death, husband dies and he has a child from a prior marriage, he's going to give a bequest to that child right away, and then wife can have free access to the remaining funds or whatever. So there's a lot of flexibility within the timing for who gets what when, and it doesn't have to be a solid pattern of spouse this, and it, you have to wait for that person to die. It's not that. You can decide on when that timing happens. You could even do, when my child turns this age, they get a distribution from the trust, XYZ. So yeah, a lot of flexibility there. And then the other when, we mentioned this earlier, is the descendants trust. Should I keep going or you want to jump in here?
Oh, I'll jump in. So yeah, this is a very typical type of trust that is created either under a will or under your revocable trust, where you're leaving assets in trust for your children who maybe at the time are under a certain age. Typically, when you're doing your will, your children are minors and you're not really quite sure what kind of people they've turned into yet. So you're just setting up a basic distribution of assets from the trust. And so while the child is a minor, or even after they turn 18, the trustee can make distributions for their benefits, for their health, education support, so pay for college tuition, extracurricular activities, healthcare, etc. And then at certain ages, that child can be entitled to receive distributions of the principal of their trust. And this goes back to what we were talking about, sort of the starting point that we start most parents off with is this: at 25, they get a third of their trust principal, at 30, they get half, and they get the rest at 35. But we have definitely seen clients who lower that, who are fine with their children receiving everything at age 18, or the converse is that extending that out even further, that they don't want to give their children assets, maybe their significant assets, until they're 40, 45, and 50. We've both seen that. So that is another example of you getting to determine, I'm going to leave these assets in trust for my child, who's the beneficiary. Here's how those assets can be distributed, and when the child can either receive distributions from the trust or the trust principal themselves.
And the note at the bottom here is also just to reassure as you're listening that there is still a process for giving distributions to children besides those ages we just talked about. So that's for distributing the principal, the main balance of the trust. But in all of those scenarios, we always recommend the trustee have the ability to give money prior. Now, there you don't have to, but usually we include that so that way, if there's an emergency, if they have things that need to get paid before they turn 25, then the trustee is the one writing those checks. But so those ages are really just when the trust lets go of those funds and actually fully hands them over to the beneficiary. The trust is no longer like actually the one writing the checks. So just to clarify that.
I think a thing to remember about a descendants trust too is that or sometimes what's called a children's trust or a family trust, is that this is the scenario where both parents are gone typically. So you're setting this up so that these assets can be used for their health and their welfare. And that's the point Makenna's trying to make, is that it's not held until they're 25. It's used for their basic care up to the point.
Yeah, that just can really freak parents out. So I always, every time I talk about descendants trust, I want to clarify.
Yeah. They're still going to get taken care of. Yeah.
Yes. Okay. So another fun term that we've seen clients play with is how much do they get?
Right.
The default is 50-50 for kids, especially, right? So for descendants trust, a lot of the time parents just say equal shares, and you do the math depending on who's living at the time of death, all of that. But it doesn't have to. You can do any number of things. You can decide on any percentages you want. There's, a couple coming to mind where, we've done different wills that are 2% here and 4% here and 6% there, and etc. Where the signer had a bunch of different charities they wanted to give to, and etc. And so, when you're setting up a trust, you can decide on when and how much, and those things can play together a lot. And then we collectively thought of some fun examples for ways that we've seen trustors decide on benefits or penalties for actions taken.
Instead of asking about how much, it's like, well, how much can I withhold is the question. These are some of these are really becoming a little bit more common too. That if especially the substance abuse or addiction, if they are aware that a beneficiary, usually a child, is having issues with this, that they want to withhold distributions if the trustee feels that the beneficiary is dealing with these substance abuse issues or addiction issues, and giving them money outright is going to just basically not be a good idea. There are other education is a big thing. If you maintain a certain GPA in school, you can get distributions. Some people don't want their kids to get tattoos or body piercings, and so they can say, oh, well, if you do, then you're going to get less money.
Or they really want to encourage getting married and having kids, and so there's for each kid you get an extra 5% from the trust,
right?
Figuring out that balance.
And while these are some of them are a little bit humorous, and some of them are very serious. We also want to explain to clients when we're setting up how and when and how much the trustee can distribute, is we want to hit that sweet spot of not being too vague but being overly restrictive. For instance, proving you got married and had kids, that's pretty easy to prove. But how does a trustee determine if somebody has a gambling addiction? And so those terms have to be pretty specific in the trust terms. How's the trustee determine that? Does the beneficiary have to be subject to an evaluation by a professional counselor?
And what happens if they refuse to be subject to that evaluation?
Right. Yeah. And can distribution still be made for them? So putting in these very specific restrictions is something you can do. But we have to understand how this is going to play out when you're gone, and maybe two or three trustees down the road are trying to figure out what did the person mean by this, and how do we actually determine if someone is having substance abuse issues or addictions.
Yep, totally. Okay, and then the last thing on our list here is termination. So you've set the terms, you've named your trustee, you've named your beneficiaries, you've figured out all the details, everything you care about is in it. The last piece is your trust has to end. When does it end? How does it end? What gets determined? Like, what determines the ending? So the example of the revocable living trust, it usually terminates when it's empty, right? Or you can direct that it gets emptied at the second grantor's death or trustor's death of, husband passes away and then wife passes away. And at that second death, the money just is distributed out to kids and the trust terminates once all the funds are gone. I would say that's probably the most common term of trust. We see that. And then with descendants trust, right, I'm skipping ahead to the bottom, but it usually terminates when the beneficiary turns a certain age. So the one we use the most is that 25, 30, 35. So when the kids turn 35, the trust is gone and the money just belongs to the child is what we usually see. And then you want to do special needs trust?
Yeah, the special needs trust will, especially with that type of trust, there really only can be that one beneficiary. And when that beneficiary, it's going to either terminate when they die. They could also terminate if they are no longer receiving benefits or determined to be disabled. But usually it's when that beneficiary passes away. Some trusts, the very small percentage, are legacy or generational trusts, where trust is held for the benefit of an individual, and then when they pass away, it's held for their children, and when they pass away, it's held for the grandchildren, and on and on and on. There is a limit to how long you can make a trust last. In Washington State, I believe that it's 150 years. There used to be a very arcane way to figure out when a trust has to terminate because it's gone on too long. Washington fixed that with a statute, but there's other states, I think, still that don't have a limit on how long a trust can go on. But for the purposes of our typical estate planning clients, we're usually talking about either irrevocable living trusts like this, or a marital trust, the Q-tip trust for the benefit of a spouse, descendants trust, and basically it's usually either age or death.
So
or if the trust is empty,
or just no longer is holding anything. That's the other one.
Right.
Okay. And then just our summary slide, there's a lot of details, a lot of variety. It just depends on what you want, when you want it set up, who is intended to benefit. And the main thing when you're going in to plan a trust is figuring out your why, what you care about, who you're trying to benefit, who you're trying to protect, what you're trying to accomplish. And so your attorney would help guide you through all of that. But make sure you're thinking about it for yourself, make sure you're happy with it. Because trusts are created for people, and that's always the focus. You get to set the terms because you're a unique individual with a unique relationship to the beneficiary. All of those things are true. And we keep that in mind for every client, where you got your own story and your trust should reflect that.
And I think just to add on to that is that we always start out each discussion that we have with any of our clients about what your overall goals are. And one of the purposes of this webinar was to introduce people to the concept of a trust and whether they might need a trust or not. And we're going into great detail about what a trust does and doesn't do and what types they are. Just keep in mind, like McKenna said, is your goals are the primary driving force behind whether you need a trust. And then if you do need a trust, what those terms are going to be. Just keep that in mind. So if you have any questions, feel free to reach out to McKenna or myself. We'd love to talk to anybody, answer any questions you might have. And please join us for our next and final part of our webinar series. Oh my God, I have a trust. Now what do I do? And so we'll walk you through some of the very specific post-trust creation checklists that can really stump a lot of our clients, but it's very, very necessary. You went through all this trouble to decide to do a trust, and then you don't take the steps to make sure that they're properly
working for you.
So looking forward to seeing and talking to everybody next week.